Good afternoon, everyone. Welcome to our third episode of this webinar series. Can you believe we're already at episode 3? Wow. So thank you for joining us today. So if you've joined us previously, welcome back. If it's your first time joining us today, welcome. It's fantastic to have you. And a special thank you goes out to everyone who has sent through questions and feedback on the previous webinars that we've done. They're great to have. Please do continue to send them through. So we've got a really great episode planned for you today. So we will be running through the responsibilities and duties of the company director. So before we dive into anything, just a couple bits and pieces. So first off, introductions. My name is Liam. I am the Service Improvement Manager with First Formations and your host for this webinar series. My role previously before First Formations, majority of my experience has been in the financial and banking industry, working in sales management and sales analysis. And joining me today again is Nicholas Campion, who is our Chartered Secretary and Corporate Governance Expert, as well as Associate Director for all things company secretarial with First Formations, as well as heading up our secretarial teams and our sister company, Linear COSAC. Like I say, we've got a great episode planned today, so we're going to do a deep dive into the roles and responsibilities of a company director. So with Nick, we're going to explore the role, what it entails, how a company director, how the role fits within the overall company structure. We'll look at the 7 key duties as defined by the Companies Act, and we'll look at any other external bodies that a company director may be reporting to, as well as any other roles and duties that may fit within the company director's remit. Now today, just before we dive in, a couple housekeeping rules. So we are on a Zoom call today, so everyone will be muted so that you can hear us properly. Any questions? We will have time for questions, so please do feel free to pop them into the chat function on Zoom. So like I say, we'll get to those questions towards the end. If you don't hear your question answered today, please don't worry. We will endeavour to reach out to everyone to ensure that you receive those answers. So we'll have time for questions at the end, but please don't stress if you don't hear it. We will get in touch. Now, as well as that, so what we're going to be doing is just quickly we'll take a look at First Formations, who we are, what we do. So we are the UK's leading company formation agent. We've helped thousands of customers incorporate their companies and benefit from concepts such as limited liability, which is that big one when you're incorporating a company. We offer our incorporation packages, we have address services, we help with company secretarial services, and our expert teams, so our customer support team and our secretarial team are there to offer support and guidance wherever you may need for your company, even after incorporation. We're there to help wherever we can. Now, we'll jump straight into this one today. So I know we've been wanting to talk about this one for a while, so the company director and what it entails. So I guess, Nick, run us through why is this such an important topic?
Certainly. To me, it's a massively important topic, the duties and the responsibilities of the directors, largely because when we talk about limited companies, Liam, we often talk in quite a one-dimensional manner. You know, registering a private company limited by shares confers a great deal of benefits as a result. You sort of already alluded to them, that big one, limited liability, so the holy grail. The whole reason a lot of, most companies go down this route is the benefits of creating that entity, the benefits of limited liability. But what's missing, what's often missed in that conversation is something that happens to a lot of people when they are registering a company, which is they also become the director. A lot of people, particularly in smaller companies, in addition to being the shareholders, they may also be the director of the company as well. And that may seem like a small theoretical distinction. I think it's anything but. By becoming a director, by taking the office of director, you are placed in a position where a great deal of responsibilities and legal duties are placed upon you. And this is something I'm very keen on helping people understand, that this is a big ask, a big thing to, a big position to put yourself in. And again, I think that's sort of sometimes missed from the conversation when we're talking about registering a limited company. And it gets, even more important, sometimes it can seem, and as we'll see in this seminar today, in this webinar today, sometimes it can get a little bit almost theoretical, or at least it can seem that. particularly if you are a small company. But if you're a company with big ambitions, or you've got other shareholders involved, other directors involved, other third parties, investors, what have you, these responsibilities and duties that are placed upon you become even greater still. And that's something that I'd like to really make sure that everybody's clear. Every person that goes through this process of registering a company and becoming a director, that they are fully aware and understanding of what's required of them. Because to get it wrong could lead you in some very hot water.
Mm-hmm. Absolutely. So I guess let's start off with some basics here. I mean, how would you describe the actual role of a director?
I think the best way you can see the role of the director is firstly actually to understand it as regards the position that the director holds and its relationship to the company. Now, we all know that the role of the director is to manage the day-to-day business of the company. What does that actually mean? What we're talking about is setting and overseeing both operational matters and setting and overseeing the strategic direction of the company. And the thing is, as the directors, you're doing that on behalf of the company, right? So you, as a director, you are an agent of that company, and you are there in your position at the will of the shareholders being the owners, the members of the company. And I would say, just from the off, during this webinar, we are going to talk a lot about shareholders as the owners of the company, because, well, over 95% of the companies registered in the UK are private companies limited by shares. But everything I do say would still be applicable for companies that are, say, limited by guarantee, where you don't have shareholders, you have guarantors instead. Now, the thing is, the directors are in a position as agents of the company to look after the business on behalf of the shareholders. That's their position. The shareholders aren't normally expected to get involved with the day-to-day work. And again, in small companies, particularly when you're just starting out, those two positions are often filled by the same person. But again, that position should be seen in the wider context of the company, which is as an agent for the company on behalf of the shareholders. That's the role.
Definitely, and I guess that's a bit of a downer for the directors. I guess we've clarified where the directors sits in the company, but what then powers does the director actually hold?
It is a bit of a downer. I'm very sorry from the off, just to be a bit of a killjoy here. But okay, so what are the powers of the directors? Well, to answer that question, let's actually go back a little bit and figure out firstly where the powers actually stem from. That's probably the best way to answer this question. Now, there's essentially four different sources that if you are appointed as a director or you are entered as a director on your company, essentially four different sources that you're going to get this from. The first of which is the Articles of Association. The second of which is any further resolutions that are passed by the shareholders, so the members, any corporate legislation, and of course, common law, the UK being a common law jurisdiction. Those are the four places where directors obtain their power from. And you could probably categorize them into two sections, one of which is authority from the shareholders, and one of which is the authority from the law. So let's look at that in a little bit more detail. The first thing I said was the Articles of Association. Now, the Articles of Association is the principal constitutional document that every private company limited by shares requires. It's such a fundamental document that essentially sets the rules on how a company is to be governed, and indeed, to an extent, how the company is to be owned. You'll find any manners of, or a whole range of powers or rules that are entered into your Articles of Association. It could state things about how directors are to be appointed, who can even be a director for that matter. It'll also state rules regarding dividends, what can be declared, how it is to be declared. It will determine how decision making is to be carried out, how the methods of communication that are going to be used. All of these things you can find in the Articles of Association. It's the directors, it's probably one of the most consequential documents in the company that and in a general sense dictating the powers that the directors have. The thing about the Articles of Association is that it is, to an extent, a living document. It can be changed. The way that is carried out is through a decision of the shareholders. The shareholders can change the Articles of Association anytime they like. All they need to do is pass a special resolution, which means more than, or 75% or more of the votes need to be cast in favour. So you want to be aware of that continual change. And it will also be available on the public records. You know, from the moment you form your company, your Articles of Association, that key governing document, will be listed on the filing history. And as a director, you know, given this is such a paramount constitutional document, what you need to do is essentially to become fluent in it. You need to know chapter and verse what your Articles of Association say, because if you go beyond it, you would be deemed to have acted something called ultra vires, or vires I should say, which is a fancy Latin word which essentially means beyond your power. So you need to be fully versed. So if you haven't read your Articles of Association, I think, you know, some bedtime reading. And indeed, if you have any other directors that are appointed onto your company, they too would need to become fully versed as well. And in fact, in larger companies, oftentimes there's an onboarding process when those directors join, for which one of the key parts is understanding what their power and what their remit is. So that's the Articles of Association. That was the first area that we receive a lot of these the directors actually get the powers from. The second area that they'll get powers from is resolutions of the shareholders, so resolutions of the owners. Now, essentially, certain resolutions essentially would have a constitutional effect. You know, it might provide a power for the director to act. For example, the shareholders might pass a resolution which authorises the director or directors to issue more shares, something they wouldn't have been able to do had that authority not been granted. So you'll notice I talked about the Articles of Association being the principal constitutional document, because it's only one part of the Constitution. The other resolutions that come through on a collective basis would all be seen as part of that Constitution. So again, it's the same sort of principle that is provided there. The third area is through legislation. The big one is, of course, the Companies Act 2006. It's been in act for about 15, 16 years now. It was actually, when it was passed, it was the longest piece of legislation ever passed in England and Wales. I think that the title has now moved on, and thankfully you won't need to, well, I don't think any director has really sat and gone back to front of that, so you don't need to go reading it in full. But again, a lot of your key powers as a director also stem from there. You know, quick example, perhaps the ability of directors to call a general meeting of the shareholders. That's where you'll find it. And then finally, the fourth area where the directors get their powers from is common law. So this is decisions that have been made by the judiciary, by the courts, that impact the power of directors. And the funny thing is, a lot of the powers that we now get in the Companies Act 2006 actually originally stemmed from common law cases, right? The director duties, which we're actually going to look on, we're going to look in detail very soon. And I know you're really looking forward to it because I've got a lot to say about it. But a lot of the director duties, the 7 director duties, actually started their life in the courts. They were a principle that came out and was since codified in the Companies Act. But the original cases still apply. So a lot of those powers, again, that come from common law remain in effect today. So that's where the powers of you as a director would come from. On a practical level, just very briefly, what does that actually mean? Well, a lot is vested in the directors. I know I talked about how they're just agents of the company working on behalf of the shareholders, and again, I'm sorry for being such a stickler here. You know, it is in some respects just a fancy title, but also it is a very important title to bestow on people. So all of the common things that you might think would be vested in the power of the directors. I'm talking the ability to enter into contracts, bind the company into contracts, to hire and fire people, to maintain supplier relations, open bank accounts, be a signatory to a bank account. All of these things, all of these powers, which again sort of stem from those four that I've just talked about, would be applicable for that director.
Definitely, and you just briefly touched on it there when you were talking about the like an onboarding process for a new director. But a lot of companies are actually formed with multiple directors. There's more than one. So what's the balance of power there between those directors?
The balance of power for directors is quite equitable, actually. In general terms, the normal rule is that every director is created equal. So if you have two directors, if you and I were, God forbid you and I went into business together, but if we both were directors, I'm only joking. If we were to both go into business together and we were to be appointed directors and we were making a decision, we would both have one vote each. Mm-hmm. The thing is, the board acts collectively, right? And I think this was an area that we wanted to discuss. So in terms of decision making, Liam, we act collectively as the board of directors or the board. And we can make decisions about the company or where the company is to go. How do we make those decisions? Again, factoring into account the sort of the one votes that you and I have. Well, there's really two main ways directors make decisions. The first of which is at a board meeting, naturally, where we'll get together, we might discuss matters, and then at the end of it have a vote. And the general rule there is that so long as more than 50% of the directors vote in favour of something, the motion passes. So if I've got two, if it's, again, Liam and I, who are the directors of the company, and I vote for a proposal, and no surprise there, Liam is voting against me again, the proposal can't carry. It would need both of ourselves. However, if there was a third person as part of our little board of directors who voted with Liam as well, then that defeats it, or if they voted with me, then that would pass it. Again, greater than 50% of the directors at a board meeting would normally be needed to make a decision. There are other ways to make decisions, with a what's called a written board resolution, and what that essentially is, it's essentially a document, a piece of paper, if you will, which has the decisions on there. And saying, well, when we resolve to appoint Anthony as a director, I don't know. And the way that we would indicate our approval is you and I to both sign this piece of paper, and once every single director has gone ahead and signed, then that decision would pass. And if we were to pass or make a decision in that manner, we would need unanimous approval amongst us. But just to go back to your question about decision making, as I say, we've got to act collectively. We're a single body. That doesn't mean we can't delegate tasks to certain directors. For example, you might bring people on for very particular purposes, very technical purposes. It could be something like a finance director, right? We could delegate the authority on them so they don't have to constantly come back to the board every time. But again, that comes from this unitary board together where collectively we are accountable. Mm-hmm.
Definitely. So just a quick recap there. So we've understand where the directors sit within the company, what their responsibilities are and the powers they enjoy. So I guess let's have a bit more of an in-depth look at the duties and responsibilities of a company director, because I think this is the big one that sticks in people's minds. And in particular, I know we could go on and on and on and on about the responsibilities of a director and what they need to do. But I guess let's just look at those 7 duties that are defined in the Companies Act. So the 7 duties that each director is required to follow.
Absolutely. Required to follow at all times. These 7 duties, you can find them in sections 171 to 177 of the 2006 Act. They originally came about, particularly the some of the early ones, I think it was up to 174, the first 4 duties. These actually, as I said a little bit earlier, actually came out of court cases where the principles were first established. And the 2006 Act, as I say, was a bit of a consolidatory piece of legislation which actually codified these things in. So they've got a long history with some very well-established principles. But anytime you act as a director, we talk about duties and responsibilities. Well, whatever you do at all times, you need to know that you need to make sure that you're acting in line with these duties. So what's the first one? Section 171, the duty to act within the powers, to act within your powers. It's a very simple one. You are only allowed to act using the authority you've actually been given and for the reason that authority has been given to you. As we discussed earlier, if you move beyond that, let's just say that something hasn't been given to you in the Articles of Association or any other source, if you act in a certain way that hasn't been authorized for yourself, then you would have acted ultra vires. The best way I can give you, the best way to give an example of this is, let's just say, very simply, you're looking to change the name of the company. Let's just say we're called ABC Limited. Okay, we want to change it now to XYZ Limited. Now, what the 2006 Act says, it says the shareholders are allowed to change the company name or through another provision that is provided in the Articles of Association. And what normally happens is actually the Articles of Association then give the authority to the directors to make that decision. But if it's not there, then the directors cannot do so, even though it's very common for directors to make that decision. If it's not in there, then you don't have the power to do so. And if you were to do so, ultra vires, you'd be acting beyond your authority. What happens if that does take place? If you do act beyond your authority, we'll come on to the consequences in just a moment. The second duty, the Section 172, do you want to just remind us what that is?
So to promote the success of the company. So obviously what the directors are there for.
So the duty to promote the success of the company. This is, you talked about how we could write books and volumes on the duties, which is absolutely true. And you could do so just on this particular piece of, on this particular provision alone. It's a massively consequential duty. The duty to promote the success of the company is talking about saying, look, you need to make your decisions for the long-term success of the company with regards to a lot of different considerations. And the Act gives you a bit of a non-exhaustive set of considerations to take into account. You need to make a decision that's good for the employees. You need to make a decision that's good for the local community. You need to make a decision that upholds, the reputation for good business. All of these sorts of things. I haven't gone through all of them, but it's a non-exhaustive list that you need to take into account. It is a very subjective section. It is a very subjective section. And let me just give you another example. Excuse me. Let's just say that you are a director of a company. That company happens to be a brewery. And that brewery is in a small village. It's a village brewery, right? It's been going on for years. Let's just say you didn't form it, but you became a director of it. That company, that brewery, you could say is a part of the fabric of the local community. But let's just say times, you've fallen on hard times. The company isn't, the brewery isn't making a great deal of money, or the margins are too small, and you realise you need to improve that position. And in this very simple example, you've essentially got two options as to how you can move forward. Option A would be to downsize the operation by, removing a lot of staff members. Option B would be to, let's say, implement a series of staff training schemes to upskill them and also to review your current processes. Are there any efficiency savings that can be made? So it's a question between downsizing, getting rid of staff, or giving the staff training and putting some process enhancements on there. Now, if we look at that decision that now we have to make as a director, or the directors, if there's multiple ones of us on the company, if we look at the decision that we have to make through the prism of Section 172, then that might push us towards option B. And why is that? Well, if we go with option B, number one, with respect to our employees, we don't have to go get rid of loads. For the local community, this is positive because it means maybe a key institution of that local village, remains strong, remains big, and remains that big part of that community. And you don't end up getting rid of a lot of, putting a lot of people out of a job. It's a subjective case. Both of those, in this example, both option A and option B are a means to the same end. They'll give you the same improvements. But by having to consider those factors like maintaining that reputation, maintaining or having regard to your employees, having regard to that local community, that might push you towards option B. I'm not saying option B is the perfect option and the correct option every single time, but that's how that particular piece of legislation, that particular duty works.
Yeah, definitely. And I guess just in that brief example you've given, love a good example, but we can see, I guess, the potential complexities involved and what should be considered, which leads us then on to, I guess, 3 and 4 in the duties when we're looking at exercising independent judgment, as well as exercising reasonable care, skill and diligence.
These two duties are pretty self-explanatory in some respect. The duty to exercise independent judgment essentially is telling you that your decisions should be your decisions. They should not be at the will, or you should not, subdue your own will for that of someone else. Let's take another example here. Let's just say that you're a director of a bed and breakfast. You run a bed and breakfast. It's quite a large one, and you're looking for a new firm who's going to take over the laundry services of the bed and breakfast. You've got a lot of bed sheets, you've got a lot of towels that need cleaning, and you've got an option between 2, maybe 3 different firms that you could potentially outsource to. However, one of the shareholders of the company maybe has a son or a daughter that works at one of the places that you're looking at, and they're very keen for you to go ahead and use that or choose that laundry service from the 2 options that you had. Now, under that duty, you can't just bow down, right? You can't just allow that person to sway your judgment, right? It doesn't mean you can't pick them just because this shareholder has a family member who's at this company. That doesn't mean that at all. It just means you can't sort of just kneel down and say, okay, whatever you want. You are an independent director, you're an independent person there to make up your own mind based on the facts, based on all of the available information you can get. And on assessing that information, you come to your own conclusion. So then that moves us to the 4th duty, the duty to exercise reasonable care, skill and diligence. And again, it's a little bit of a self-explanatory duty. There's actually 2 tests that are looked at when deciding, when we're looking at whether this duty has been fulfilled by a director. It's an objective one and a subjective one. But essentially, the way a director is assessed on this duty is, would a reasonable person in this position have taken that decision? And the second test is being, of course, factoring in to account your actual experience and your actual skills. Did you exercise that level? It's not enough. It may not be enough to say, well, I did my best, because that may be true, and that may help you with that second test to say, well, based on your experience, you did as much as you can. You went as far as you can. But as I say, that may not be enough, and we would be looking more at the objective, the objective test here, which is, would a reasonable person in your position have done the same? So here's another example. Let's just say it's not going to be a bed and breakfast this time. It's going to be a restaurant. Let's just say you're opening a Mexican restaurant, and you have a choice of 2 locations to open a new branch. The first location is by a busy high street, lots of foot traffic. The second option is at the bottom of the marina trench. By reviewing this decision with regard to your duty to exercise reasonable care, skill and diligence, you probably, in this case, would firstly weigh up the risks of both locations. You would get all the available information that you can. You might consult with experts in determining how you should move forward. And once you have completed that, under this duty, you may well come to the conclusion that Mexican food may not be very popular or may not have that great a demand when it's about 13,000 feet under the ocean surface, and that's why you might go for that high street location. So again, a little bit self-explanatory. You need to be able to, these are the decisions you make and the actions you make are not something that you should take lightly. They're not something that you should simply brush off and hope for the best. Close your eyes and hope the right decision is made.
And it is, I guess, comforting in a way to know that these are kind of self-explanatory, but obviously good to know, well, imperative to know. But just rounding off the last three that we have the duty to avoid conflicts of interest, the duty not to accept benefits from third parties, and a duty to declare interest in proposed transactions and agreements.
Yeah. So we'll rattle through these ones. The duty to avoid conflicts of interest. So, you as a director should not put yourself in a position where you have a conflict of interest with the company or that you may have a conflict of interest in a company. A very simple example is you might not want to be a director of a company, but also the director of another company which happens to be a competitor of that company. That's not to say conflicts of interest are completely prohibited. You can have them approved in certain circumstances. Normally it is the shareholders who provide that approval, and in some circumstances, indeed, the board, your other directors, if you have them, may also have that power as well. So these interests, they can be direct or indirect. They can be based on family members. It might not be you who's the director of the other company, but it's
like a spouse or partner, or someone like that.
Yes, a partner or a familial connection. So that was the duties, or the duty to avoid conflicts of interest. The sixth duty here is the duty to not accept benefits from third parties, which, again, pretty self-explanatory, this one. You can't accept benefits as a result of decisions that you have made as a director or simply because of your position as a director. So, again, let's take another example. Let's just say that you own and run a company which needs to scale up, and it needs to scale up fast, and you decide because you've got to get bodies into your business, you need to get more staff, that you decide to retain the services of a recruiter. And maybe there's a choice of 2 or 3 recruiters, but maybe one of these recruiters decides, hey, we are going to pay for your holiday to Santorini, Lake Como, wherever it is that you might like. I heard they are very popular, those places. Now, in your position, you would not want to accept those benefits, not least from what that would do to your judgment. Remember, these duties are not mutually exclusive. In addition, if you were to take them to take the benefit, not only breaching that duty, that might impact your ability to exercise reasonable care, skill, and diligence, because maybe your mind has been swayed, or maybe you're acting in a way that is you're being influenced by somebody else. And that's not even taking into account things like the Bribery Act, the Bribery Act 2010. All of those things would come into play. So you would not want to accept those benefits because of your position as a director. And the final duty here is the duty to declare interest in proposed transactions and arrangements, which very simply is before a company is going to go through a certain transaction or what have you. If you do have any interests that may be relevant here, and those interests can be direct or indirect, then you would want to declare them to your other directors and the company before going through it. Again, it may be a case that you can still retain your interest, retain your directorship whilst retaining your interest, but the point being is before going ahead, you need to make that declaration to the company.
Mm-hmm. And we've touched on it a little bit just previously, but I mean, we are all human, so what happens if, God forbid, there is a breach or...
I think that would entirely depend on the situation. So I can't comment on specific cases, but let's look, the general rule is if there is a breach of the duties, firstly, the company may bring legal action against you as a director. Remember, your duties as a director are owed to a company, not the shareholders, right? So the company may bring action against you. That's not to say the shareholders can't start anything, they can't initiate anything. And whilst the shareholders can't sue you in your position as a director, they can bring what's called a derivative claim against you on behalf of the company, right? So those are two, very, very, very serious things to take place. And even more serious is that on occasion there may be criminal sanctions or criminal penalties that will apply if you have breached the duty. And let's not get too caught up just with the legal side of things. If you're not the only director that's appointed to a company and you have breached your duties, well then perhaps some of the other shareholders might decide to remove you, okay? And that's a very real prospect if there are shareholders holding greater than 50% of the votes in the company. Why 50%? Well, all it takes under Section 168 of the Companies Act to remove a director is simply an ordinary resolution, which to be approved requires greater than 50% of the votes cast in favour, right? So, and all it requires is that some extra special notice is put on. So it's not just about the legal side. If you breach one of those duties, you may have action brought against you by the company or on behalf of the company. You may find yourself facing criminal penalties, but also from a practical side, other people in the company may decide that you shouldn't be there.
And I guess just quickly on a side note, would I be right in assuming that these 7 duties aren't just going to be, or they're not just the sole responsibilities of the director?
In what sense, sorry?
So, I mean, thinking that they're, like, are they going to then extend to others within the company, or?
I mean, the duties themselves are only focused in on the directors themselves. Yeah, so I mean, they're closed in the name. But for the avoidance of all doubt, what I've just told you is just the general duties of the directors. It doesn't take into account anything else with respect, any other responsibilities that are conferred on you by the Companies Act or something. This is, we haven't even talked about the administrative matters that they need to deal with, the record keepings and so forth. All we're talking about is the regular duties every company, every director will need to factor in.
Yeah. And so when you mention so government bodies and administrative duties, are we talking about bodies like Companies House and HMRC?
Yeah, I mean, those are the two big ones. I mean, there's loads out there, right? There's lots of bodies that you will, in some form, have to deal with, and it will be your responsibility as a director to deal with them. And I'm talking about people like the Information Commissioner's Office, the ICO, so your data protection registration with them. It could be with the Office for National Statistics, the ONS. These guys, again, they'll want surveys completed about you, they want to know about your company. All of these bodies, the responsibility for fulfilling your obligations would be placed on them.
And just, well, you mentioned that they are the big two, so I guess quickly, I know we've gone over it in other webinars, but just quickly, if we define, I guess, Companies House and HMRC, just so we're clear.
Yeah, it's good that that we run through this again, because they are often confused with one another. Completely different organisation, government bodies. Companies House, very simply, has 3 jobs. One of them is to incorporate companies, that's to accept incorporation applications, the IN01 form, basically what we do a lot of the day. They are also there to dissolve companies, close down companies that either compulsorily, that they're not when they're not required, or on a voluntary basis, the companies that do want to leave by their own volition. Finally, Companies House are also there to accept any filings that the companies have to submit, and specifically that the directors would have to submit. That's their duty to do so throughout the life of their company. HMRC, on the other hand, as I say, completely different body. What they are interested in is two things. Number one, the completion and payment of tax that is owed. Mm-hmm. They're there to collect tax. And number two, they're there to enforce tax legislation. So very different bodies with very different remits. But particularly in the early stages of your life, these are the two bodies that, as a director, and you're factoring into account your responsibilities, these guys are really going to be on the forefront of your mind.
Definitely, and I guess as they are the big two, with regard to the director and what they would need to do with Companies House and HMRC, if we start off with Companies House, as they're going to be the one that most people are initially going to deal with, what is the responsibility of the director when it comes specifically to Companies House?
Well, specifically to Companies House, there's essentially two main categories, which is the first of those categories is the annual company filings. The filings that every single company has to complete and submit to Companies House. What are they? They are the annual confirmation statement and the annual company accounts. The annual company accounts is that snapshot, and we have spoken about it, and I'll just quickly run through it. Is the annual company accounts is that snapshot of the financial position of the company. That gets submitted once a year, and it has to be in 9 months after the date, the accounting reference date, so the financial year end. That contrasts with the confirmation statement, which again is an annual filing, and it provides a snapshot of the company in terms of its ownership, who owns it, in terms of the shareholders, what is the business doing, and so forth. It also confirms that everything else that's been submitted to the public record is also correct. Those two filings are so fundamental, and the consequences of not doing so are also pretty severe too. So failure to do so first and foremost, they're criminal penalties. The criminal penalty, they are criminal offences committed by the officers, the directors. So you want to make sure you do everything in your power to get those submitted in, and get those submitted in on time. Otherwise, you could face prosecution. The second element is that automatic financial penalties may be levied against the company. This is specifically the case with the annual company accounts. The second you are late and you submit your annual accounts late, you will be fined. The company will be fined. And thirdly, you may lose the company. The company not filing these, in addition to being a duty, is also a failed duty, is also seen as a suggestion that maybe this company isn't needed anymore. Well, hang on, those directors aren't submitting those basic filings that everybody has to submit each time. Maybe this company isn't required, so they start closing the company down. Companies House decide, okay, this is our marker, we'll start by closing this entity. Absolutely. That's not even taking into account the non-legal matters, mm-hmm. which is the reputational damage that can be inflicted on the directors who fail to do so. Again, it's such a fundamental responsibility in the part of the directors that they need to carry it out.
Absolutely, and one that we get asked about a lot in these webinars, and I think there does tend to be a bit of confusion, especially with accounts going to Companies House and a tax return going to HMRC. But when it comes to HMRC as opposed to Companies House, what are the responsibilities of the director with HMRC?
Well, the directors have essentially three responsibilities to HMRC, and they can be categorised as registration, the completion of regular submissions, and payment. So those three things, if you take it from a corporation tax perspective, if your company begins to trade, well, then you need to be registered for corporation tax within 3 months. And that's a duty of the director to ensure that happens. And if that's at incorporation, then 3 months after incorporation, you needed to have completed registration. VAT, if your company is going to exceed the £85,000 threshold, By the end of the month, say factoring into account the last 12 months, then the directors would be required to ensure that the company has registered for VAT. And indeed, if you're looking to pay someone a salary, then the company would be required, and therefore it's the duty of the directors to ensure that they have registered the company for the purposes of PAYE. And that's just the registration, because there are also submissions that need to be completed. With the corporation tax return, you need to complete a return, the CT 600 form, again, something for the directors to deal with, 12 months after the end of the accounting period. VAT, it's done on a quarterly basis. Every 3 months, you need to submit a VAT return. Again, that's in the park of the directors. And again, even on paying corporation tax, you need to ensure that you pay your corporation tax 9 months after the end of the accounting period. So it's actually a bit sooner than when you actually have to get the CT 600 form in. Again, that duty is placed upon the director. VAT, usually I think it's 1 month and 7 days after the end of that period that you need to have submitted or paid the VAT amount to HMRC. And similarly, there is a payment, I believe it's going to be made by the 22nd of every month to HMRC as regards PAYE. So again, these are regular registrations, submissions and payments. And as agents of the company, you need to ensure that is completed.
Definitely. So we've looked at the bodies. So we've looked at the Companies House, HMRC. We've even mentioned the ICO and the ONS. So moving on from the company, the different bodies that a company director will have to be responsible for dealing with. What about any other legislation that they should be aware of?
We focused a lot on the Companies Act 2006, which is the principal piece of legislation, but there's all sorts of legislative pieces that you need to factor into account. Unfortunately, it is outside the remit of this seminar. But what are we talking about? We could be talking about, I talked about it earlier actually, the Bribery Act and ensuring compliance with that, data protection, GDPR, relevant consumer laws, employment laws, all of these things. The onus for compliance under these pieces of legislation against agents, as custodians of the companies, fall upon you. And you would need to and indeed want to make sure that the company is following them at all times.
And just finally, before we jump into some questions, so now we've looked at the responsibilities and the duties of a director, where they fit in the company structure, as well as the where their powers come from and the different bodies and legislation. Are there any other responsibilities that need to be undertaken by the director?
Yes. I think there's probably 3 key ones, and they're very much internal responsibilities. Large, as I say, about record keeping. The first thing is the duty to retain your accounting records. You need to. This goes with your duty to make sure you get your annual accounts in, because how can you put your accounts together if your accounting records aren't kept in order? It's your job to make sure they are kept in order, and indeed that they are kept safe and accessible. In fact, I think the accounting records have to be kept for at least six years before you can think about removing them if you were so inclined. The other area is maybe maintaining board minutes, keeping records of any meetings that take place. So we talked earlier about how boards make decisions. How do they make decisions? Well, one of the key ones may be through a board meeting, when everyone gets together, discusses something and comes up with a decision. Well, if you hold a board meeting, then you need to minute it and keep those minutes safe. And I think that has a 10-year storage requirement. And the final thing that I think is important in this particular point to discuss, the final point is the maintenance of the statutory registers of a company. What are the statutory registers? These are essentially the Bibles of a company. They say who owns the company and who controls it, who directs it. So you if you want to be a director of the company, you need to have your name in the register of directors. If you want to be a shareholder of the company, your name needs to be in the register of members, or the register of shareholders, as it's sometimes called, with your name and how many shares you hold. If you're not in there, then you're not either of those things. And the responsibility, not just for putting them together, but also maintaining them, then that falls on the directors themselves. And you can probably see why. It's a very important, very fundamental area. Again, squarely in the park, in the directors.
Lovely. And so now we'll take some questions. Now we do have a lot of questions that have come through. So like I say, we will try and get through as many as possible. Like I say, if we don't get to your question today, please don't worry. We will endeavour to reach out and get those answers to you. But just to start us off, I've got one from Jason. So do you need to have a UK directors to operate a company in the UK?
No, there is no requirement at all for your directors or any of the directors to be residents of the UK. You can have a company that is entirely managed by directors that are non-resident. That also goes for ownership as well. There is no requirement in the UK that your directors or shareholders or anybody has to be domiciled in the UK. Very simple, and you know it's very very free, very open.
And a nice easy one, which we did briefly mention earlier, but we'll ask it again. So we've got this one from Maurizio. Can shareholders and directors be the same person within a company?
Yes, certainly. And when you register a company, when you're just starting a company out, that's actually probably the common, the most common situation you're going to find yourself in. You can take up both positions. The positions are entirely separate from one another. There's, it just so happens that most companies that set out, there's only maybe one person who's gonna do all of the above, to deal with all of the responsibilities, to own the company. Yeah, you can definitely hold both positions. There's nothing that says you can't hold. You can only hold one position, maybe not the other. You could even throw in being a secretary in there. You could be the company's only director, only secretary, and only shareholder all at once.
And we've got another one here from James. So in a single director company, do I really have to vote on a resolution whenever I make a decision?
I mean, if you're a sole director, which means you're the only person on there, I mean, I guess you making a decision is the vote, isn't it? You don't really have meetings with yourselves, so you may still want to minute the decisions you have made, particularly if you're looking to scale up the company and maybe in the future you're going to have other people at the business. But no, I mean, it's not a case that you have to sit in a room and take roll and say, right, do I agree with my decision? Yes, I do. I don't think that's the case. I don't think you have to do that. But again, it's easy because you're a sole director. You may still want to, and I think it probably is good practice that you do minute your decisions, you do record your decisions. But no, I don't think that would be strictly necessary.
I've got an interesting one here from Dominique. So thanks, Dominique. I'm a bit confused about what constitutes a benefit from a third party. If shopping around for a supplier and one supplier offers a gift voucher if you sign up to them, can I not use that voucher? Or should I not sign up with them?
It's a difficult one because, benefits can be financial and non-financial, so the fact it's not literal money would have no bearing here. I think that so long as, if it was given as maybe as part of a trial to help understand how the relationship works or how this supply works in particular, I don't know if that would be a problem. But merely being given one or a voucher, what have you, because you are a director, I would probably, and I'm not a lawyer here, and as I sort of alluded to, everything's taken on a case-by-case basis. I'd probably be less inclined to accept that benefit. And again, if we remember that all of the duties, they're not necessarily, they're a single. You may have multiple duties to factor into account here. It may not be just the fact that, okay, I can't accept third benefits from these guys, I would also be considering, how does this impact my ability to exercise independent judgment? How does this, will this affect my ability to have that, to implement that reasonable care, skill and diligence that I'm required? So yeah, I don't think, if it's given to you purely because you're a director, then I would be less inclined. As I said, if it's something that's more of something that's as part of helping the company find out how the supplier works, maybe you do sort of like a mystery shopper thing, I don't know. Maybe that'd be a little bit different. But yeah, just getting it because you're a director, I'm not so sure about that.
Yeah. And another one we've got, my company just started trading within the last month, but there's no revenue at the moment. Do I still need to submit corporation tax?
If there's no revenue, all right, HMRC's definition, you said you've started trading, but you haven't had any revenue yet. HMRC's definition of trading, or more specifically, the requirement to complete corporation tax returns is the company trading or not. It's less so about what's going in or out of the company. So I would say that you probably still do need to register for corporation tax there. It'll probably be come the end of the year. Remember, these generally are 12-month accounting periods for the purposes of corporation tax. You probably will have to complete that. But if you've started trading, regardless if you got revenue or not, I would suggest that you probably do need to register for corporation tax, and in particular because come the end of it, you probably will have something to submit or something to pay.
And this one you may have briefly touched on when we talked about companies with multiple directors, but I've got one from Sharif. So I'm looking to set up a company with my brother. We're going to be joint directors and shareholders. How do we set out who is responsible for what?
Articles of association, that's the place that you really want to put it, because as I said, the default is that everybody is, the board is collectively responsible for fulfilling all of their duties. So if you have someone that you need to, if one of these persons, say, is better on an operational element and you want them to focus on the operations, then I'd probably be looking at sticking something into the Articles of Association which is going to put that responsibility specifically in the park. Again, the authority still flows from the board and you're still collectively responsible, but at least in that case, your brother wouldn't have to constantly come back to the board and routinely ask for questions. So very simply, I would suggest sticking that into your Articles of Association.
And I've got one from Laura. So my company is dormant and I've let my annual accounts due date pass. I understand there is now a penalty fee to pay. Must this come out of my pocket, considering the company currently has no income? I'm assuming she's meaning as the company director.
Yeah.
Yeah.
I don't think Companies House cares who pays it. My experience is that when a company has received a fine, Companies House, when a company has submitted their accounts late, they get a letter and they say, thank you very much for sending those accounts in. They were late. This is how much you got to pay. And quite literally, they put a little slip at the bottom, fill this in with your details. I don't think it has to come from the company. If you're dormant, how can it? So I think from their perspective, they're just very keen to ensure that fine gets settled. And yes, I think that in my past experience, sometimes the owner director is simply just the one that pays it, and that's the end of it. Having said that, just FYI, if you are a dormant company and you do have a fine to pay to Companies House for late filing penalties, you can actually pay it and not affect your dormancy status. So paying fines to Companies House isn't considered a significant accounting transaction. So even if you did pay that, then I think you would still be able to retain your ability to submit dormant accounts to Companies House. But yeah, as far as Companies House or anybody else is concerned, is just get that settled and be done with it. When I say directors having particularly a special interest there, just get it settled.
Definitely. And in First Formations, if you did want to have the dormant company accounts filed correctly, we offer a service for this. We actually offer an express service for the dormant company accounts if you have gone past the due date. So get in touch and we can help you file that. Now, one here from Emmanuel, and I'm pretty sure I can answer this one. But we've got, how many directors is the lowest number that can operate a company?
Should I find a new job?
Maybe. But I believe, correct me if I'm wrong, private limited companies in the UK require at least one natural director to operate.
That's the law. The legal minimum is you have to have one director if you're a private limited company. Obviously, if you're a public company, sort of outside the remit of today, then you would need at least 2 directors. You need one person who is a natural person, so not a body corporate, not a corporate entity. Obviously, if your articles of association say that you have to have more, then you would need to have more. But if we're specifically talking about what the law says, it's one director.
Easy. And I think we've got time for a couple more. We can squeeze a couple in. One we've got here is there a time limit in which a director must register the company for the purpose of PAYE, and is there a penalty for late compliance?
I mean, if you're going to pay, you need to, I think you have to have registered the month before, or the month before you are due to pay the person. I think that's the rule there. Non-compliance, I think I'll actually have to plead the fifth on that one. I can't recall off the top of my head the consequences for doing so. So I apologise for that. We'll get back to you. Who was that submitted it in?
Don't worry, I can make sure we get back with an answer there. That's fine.
Yeah, no, I'm sorry. I don't recall off the top of my head the penalties for non-compliance, but yeah, we'll get back as soon as we can.
Easy. And we've got another one. So there are 6 directors in a company. What if 3 of them block a decision that is vital for company operations? We're getting deep here.
We are getting. I mean, well, first and foremost, if they've blocked a decision, then the decision hasn't been made. If you have that meeting at the board meeting, for example, you need greater than 50%. I mean, that's the general rule that most companies will operate under. So, if it's vital for the company's survival, I don't think that would change the position. You know, what the other directors have to consider is all of the duties we've spoken about today. You know, is their decision, does it promote the long-term success of the company? Is that something that they're doing or making a decision that's their own independent judgment? Does it demonstrate that level of care, skill and diligence that's required of directors? So if a group of directors feel that it is vital for the survival of the company that this decision is made, then fair enough. And if another set believe it's not, then that may be fair enough too. But you'd probably be looking at whether they are fulfilling their duties there to the company. Remember, they owe that duty to the company, not anybody else, not the shareholders, not each other. They owe it to the company. If they're failing to do so, that would probably be something for them to consider. But to answer the question specifically, the nature of the decision, which again, these things can be so subjective. Now, I don't think there's actually really much you can do, even if you do believe this is sort of existential to the company.
Definitely, and I think that is pretty much all we have time for, but I promise we will, any questions that weren't answered, we will try and reach out and get some answers to you, as well as that one about the PAYE. Don't worry, we won't forget. But thanks everyone who has joined us today, and like I say, we will try and get the answers out to those questions. If you did want to go back and re-watch some of this video, or perhaps you want to go look at episodes 1 and 2, so those videos, or today's video will be up on YouTube. Give us about 24 hours and we'll get that up there for you. The other 2 episodes, so episode 1 and 2, are already up on YouTube. So episode 1, we went through life after incorporation, so discussing some things important things you may need to know when incorporating a company. And then episode 2, we went through what you can do after incorporation, so things like upscaling your business and things to be aware of there. So great videos to check out too. Now, any further questions, if you did want to get in touch with us, please do email any questions you may think of afterwards to talks@firstformations.co.uk, or give our team a call. Our customer support team are more than happy to speak to you and answer any questions you may have. And if you did want to see more, or you want to have a bit more of a look into all things company formations, we have a number of blog posts, heaps of them, on our website that you can read through, or the YouTube channel does have many, many more videos where you can see more of Nick and go into a bit more detail into a whole range of topics. But aside from that, thank you so much for joining us today. Hopefully we will see you again on the next episode. But aside from that, please have a great evening and thanks.
Cheerio.
Bye.